Ms. Anthea Ong.
Mr. Speaker, I welcome the Criminal Law Reform Bill. As Thomas Jefferson said, laws and institutions must go hand in hand with the progress of the human mind. I'll be addressing 3 areas of the law reform today. First, enhanced punishment. Second, the abolishment of marital rape immunity and changes in definition of rape and consent. And third, the decriminalization of suicide. First, enhanced punishment. I wish to comment on the government's acceptance of the Penal Code Review Committee's recommendations relating to the extension of enhanced penalties for offences committed against the vulnerable amongst us, namely domestic helpers, vulnerable persons, persons below 14 years of age, victims in intimate relationships, and victims in close relationships. The purpose of these sections is clearly to recognize the systemic vulnerability of certain victims and therefore the need for commensurate enhanced punishment. However, Mr. Speaker, I'm confounded by the incongruence between the policy basis underlying the enhanced penalty regime, acknowledging an inherent power asymmetry, versus the newly proposed subsection 73, subsection 2 in clause 15. This subsection renders the section setting out enhanced punishments inapplicable where the accused person is able to prove that his or her relationship with the victim did not adversely affect the victim's ability to protect themselves from harm. Similar wordings appears in the proposed subsections 74A to A, 74B3, 74C3, and 74D3 found in clause 18 of the bill. In practice, this provision could potentially require the victim to prove that he or she could not have done more to protect himself or herself. There are sadly enough cases of domestic worker abuse. One employer was charged last year for having punched her domestic worker so much over the course of a 2-year period, such that the latter had become blind in her left eye, in addition to suffering from an injured right eye. It is not difficult to imagine a similarly abusive employer, in an attempt to avoid being sentenced with enhanced punishment, citing the exception provided in the proposed subsection 73(2) and claiming that the mere fact of employment did not adversely affect the domestic helper's ability to raise her arm to stop the punching. I therefore urge the Ministry that the above-mentioned sections be supplemented with illustrations to clarify the scope and limits of the new provision, if the provision is not omitted altogether. I do, however, believe that this should be removed, as it inadvertently leads to harsh scrutiny of a victim's actions, which encourages a culture of victim blaming. Mr. Speaker, equally important to the continued protection of vulnerable persons and groups is that of education and raising awareness. I would like the Minister to clarify on the Ministry's effort to work with relevant community partners such as schools, employment agencies, family service centers to train and raise awareness on the new laws and the additional protection offered to the vulnerable that they support. Next, on rape. I would like to express my full support for the amendment to abolish marital rape immunity. We're sending a strong signal to where we stand as a society with protecting and advancing women's rights. Mr. Speaker, let me also take this opportunity to commend the expanded legal definition of rape, which now uses gender-neutral terms and incorporates many more exploitative scenarios. This is a significant change because it acknowledges that men can be victims of sexual harassment and assault too. Not only will male survivors be able to seek legal remedy under this new definition, but this also implicitly acknowledges the unique struggles and social stigmas that male survivors face. As a society, we should move towards destigmatizing issues related to sexual assault and provide more support to all survivors regardless of gender. Mr. Speaker, even though the legal barriers for reporting rape are now reduced, there still exist other barriers that discourage rape survivors from actually making a report. For a start, there is an immense informational gap in the definition of consent in our laws versus the layperson's understanding of the same. I strongly urge for a clear and positive definition of consent for the purposes of judicial review and public education. The Penal Code Review Committee decided against making changes to Section 90, citing its general ease of application in court. I understand the committee's concerns and acknowledge from the briefing notes on CLRB, this bill, that the government intends to create a new section to set out types of misconceptions of acts that will vitiate consent. However, I'm concerned that these measures might be insufficient in addressing the problem at hand. For example, I know of such a case cited by Aware Sexual Assault Care Center, or SACC. A survivor initially consented to have sex, but later withdrew her consent when she realized that the man was too drunk and was being verbally abusive. However, he threatened to hurt her, so she eventually complied with his demands for her own safety. When she went to the police, she was told multiple times, and I quote, "But you did consent initially," unquote. This discouraged her from formally making a report, as she felt she had no case, which was inconsistent with the precedent set by case law. Case law presents a different yet more straightforward definition of consent compared to what is currently defined in the Penal Code. It covers a number of situations where consent is negated. However, the definition of consent, as developed by case law, is not codified nor easily accessible. I recommend that we adapt Rantailal and Diraj Lal's definition of consent, which was referred to in Prem Nair versus PP 2017. For ease of reference, the proposed specific definition of consent for sexual activity should be created under sexual offences of Chapter 16 in the Code and should be defined as, I quote, "Consent is the free, informed, and voluntary participation in the sexual activity in question. Lack of resistance and submission to sexual activity in itself is not consent as a matter of law," unquote. This encompasses the elements of free exercise of choice, voluntary participation, and the exercise of choice based on the knowledge of the significance and moral quality of the act. I also propose the government includes a section to set out 6 specific situations where either there is no consent in law or no consent is obtained. Situation 1, where the consent to participate is expressed under fear of injury or wrongful restraint to the person or to some other person, including the accused. I would like to bring particular attention to the addition of the words "including the accused" to account for the type of situations that SACC has come across where the accused threatens to harm himself if the complainant does not comply with his demand for sexual intercourse. Situation 2, where the consent is given by a person who from unsoundness of mind, mental incapacity, intoxication, or the influence of any drug or other substance is unable to understand the nature and consequence of that to which he gives his consent. Situation 3, where the consent is given by a person who is under 16 years of age. 4, where a person says or does something to show they are not willing to continue an activity that has started. 5, where the accused causes or induces the complainant to participate in the activity by abusing a position of trust, power, or authority. One could argue that this is already recognized in the proposed section 3753C on exploitative relationship, but that is only for minors. An exploitative relationship can also be a superior coercing his subordinate at the workplace into sexual activity. And 6, where the consent is expressed or implied by the words or conduct of a person other than the complainant. This scenario would be applied to situations that SACC has come across where a wife's consent is assumed if her husband told another man that he can have sex with her. Mr. Speaker, I urge for more to be done on public education, including comprehensive sex education in schools, to improve the public's understanding of consent. Sex education programs need to explicitly discuss the meaning of consent and what it means in practice. Lastly, I would like to comment on the decriminalization of suicide, an issue very close to my heart, given the people I know around me, far and near, who have contemplated and attempted suicide. Suicide is a taboo topic in Singapore. This bill offers us as a society an opportunity to break the stigma by having a national conversation about it so that more can come forward to seek help. Because these escalating statistics across all ages of our populations are telling us we must. Children aged 5 to 9 calling the Samaritans of Singapore hotline increased by more than 500% in less than 3 years. Suicide is the leading cause of death for those aged 10 to 29. The number of elderly aged 60 and above who took their own lives peaked in 2017, the highest since suicide tracking started in 1991. First, Mr. Speaker, we must de-link the convenient and linear association between suicide and mental illness. Many studies have conclusively absolved mental illness as the only cause of suicide. Research has shown that mental illness is associated with 62% of all suicides in Singapore. There are two other risk factors that make up the other 38%. First, life events. For the young, relationships, academic stress, national service for the young. For the elderly, bereavement, debt, feeling lonely and fear of being a burden. And for working adults, marital, financial problems like unemployment or failed business, as well as legal problems. And the second risk factor is physical illness, another risk factor, which means that suicide associated with physical illness not unexpectedly increases with age. I wish to therefore express my concern that the police referring a person attempting suicide to a medical practitioner may inadvertently categorize all suicide attempters as having mental illness who need a medical condition, and as such not be given the optimal and multifactorial approach he or she needs at that point of distress and after. There were 361 suicides in 2017 according to SOS. The latest number for attempted suicides is not available, but in response to a parliamentary question raised in 2015, MSF reported there were about 1,000 cases of attempted suicides each year between 2010 to 2014. Because suicide is a crime under Section 309, reporting of suicide attempts is mandatory as provided for in CPC, the Criminal Procedure Code. This will not be required with the repeal. The WHO World Health Organization urges society and the individuals themselves not to associate suicide with immorality, but to approach it with compassion, which I completely agree. It also said that decriminalization reduces suicide rates. Yet there have also been studies of 7 nations, Canada, England, Wales, Finland, Hong Kong, Ireland, New Zealand and Sweden, that present a contradicting conclusion where suicide rates were actually higher after decriminalization. So I reluctantly did a deep test with those around me who have contemplated or attempted suicide. None knew that committing suicide was a crime in Singapore at that point of their attempt, and most added that it would not have deterred them even if they had known it was. Therefore, I'm also not convinced of the deterrent effect of Section 309 in preventing suicides. In addition, we know that only 0.6% of reported cases of attempted suicide resulted in prosecution each year between 2013 and 2015, which has surmised that at least in recent years our police officers have been taking a compassionate approach, in practice anyway, despite suicide being a crime. Mr. Speaker, I think we all agree that a person in distress and attempting suicide should not be treated like a criminal and must be shown care and compassion with the necessary professional and psychosocial support. The repeal of Section 309 to decriminalize suicide most definitely helps to destigmatize suicide. However, I'm concerned that this repeal is not supported with a clear post-decriminalization strategy, including enhanced psychosocial first aid training for police and SCDF officers, coordination between the police, SCDF, IMH and support agencies, including tracking and monitoring of suicide attempts and support structures to course correct should suicides go up after decriminalization. With the rising numbers of suicides with our young and our elderly, decriminalization of suicides must not be done without reviewing and rebuilding our systemic response towards suicide attempts. We must do more to raise awareness of suicide risk factors, shift perceptions on mental health, and deepen community-based efforts in active monitoring, reporting, and help seeking. We must do more to counter the threats of rising suicides amongst our young and elderly. The latter is likely to rise with our aging population, whilst the former is also predicted to escalate with the unrelenting pace of a fast-changing digital dominant future. In conclusion, Mr. Speaker, the proposed amendments in this criminal law reform bill demonstrate to a large extent that our laws are keeping a pace with our aspirations of being a more inclusive society, especially in the greater protection given to the vulnerable, such as minors, persons with mental or physical disabilities, domestic workers, and sexual assault victims. However, we can and must continue to do more for other minority groups that are still stigmatized by our laws, such as 377A. Because through history, we have never made or changed laws only for the majority within our society, including this bill. Notwithstanding the above clarifications, Mr. Speaker, I support the bill.